start with Senate Bill 2117, the Juvenile Offender Bill, provide alternative sentencing and parole options. We'll ask Mr. Samsel if he will to explain that one. It's based on a recent court ruling.
Sure. Thank you, Mr. Chairman. Senate Bill 2117 just conforms the homicide statute, sentencing statute, and the parole statute to Miller versus Alabama, primarily, and then a couple other Supreme Court cases as well. The court in Miller versus Alabama held that the Eighth Amendment's prohibition against cruel and unusual punishment forbids mandatory sentencing of life in prison without the possibility of parole for juvenile homicide offenders. So the first section, section 1, is 97-321, it's the crime of homicide, and it provides for separate crimes for juvenile offenders. And it defines a juvenile offender as a person who had not reached the age of 18 at the time of the commission of the offense. And that language is on lines 29 through 31. And then it lays out the offenses for first and second degree murder and capital murder. And then it says if the court sitting without a jury finds the imposition of a life sentence to life imprisonment or life imprisonment without eligibility for parole to be unjustified, the court shall fix the penalty as follows. But if it is justified, the penalty is above in paragraph B. But then as follows, if it's not justified, if the crime is not justified, then for first degree murder, it shall be 20 years, nor more than 40 years. Second degree is at least 15, nor more than 30. Capital murder, at least 25 and no more than 50. And then the language in paragraph D there, the provisions of this subsection apply retroactively. That's in conformity to another Supreme Court case, Montgomery versus Louisiana. Section 2 is sentencing in capital cases, and it's currently on the books and used. But what this bill would do would just add language that would conform Miller versus Alabama's holding, as well as Roper versus Evans, which is an older Supreme Court case that says that a sentence of death can't be imposed on a defendant if he's a juvenile, 18 years of age. And there's case law in Mississippi that the court follows, and this would just be bringing the statutes in line with that. The language is if the defendant was under the age of 18 years of age at the time of the commission of the offense, subsection 9 of this section applies. And subsection 9 is further on lines 187 through 199. And this is really the meat of Miller versus Alabama. As the defendant was under the age, the court sitting without a jury must conduct a separate sentencing proceeding to determine whether the defendant should be sentenced to life imprisonment without eligibility for parole, or imprisonment for a term of years. And the language there is that the court in its deliberation shall consider a number of factors, and those are the Miller factors. And then section 3 is just conforming this language to Miller and for the parole statute. And that language is at the end of the parole statute in a new subsection 5. Lines 351 through 357, and that's an explanation of the bill, Mr. Chairman.
All right, thank you, sir. First, for any questions on the bill, and then I think Senator Barnett may have an amendment to the bill. Any questions for our esteemed legal counsel? You did a great job explaining that. Senator Turnford, yes, ma'am.
Thank you, Mr. Chairman. And I do appreciate the explanation. And I think once we got to subsection 5 on the last page, it answers my question, but I want to be sure that basically for those sentences that have been imposed prior to the enactment of this statute, and if it's a juvenile who was sentenced to life in prison without parole, they can be considered for parole after 20 years. Is that how this would work?
That's correct.
Okay. Thank you.
Thank you, Madam Chair. Senator Simmons.
Question, Mr. Chairman.
Yes, sir.
Yep, and on the last section that Senator Ford just mentioned, there's a juvenile parole eligibility act that I sponsored, and some language there. I think Ethan, you helped me draft it, but I think the language there was for juveniles 20 years and or 50%, whichever one is less. Is there any particular reason why for juveniles we don't want to do that? Because with the current language as in the proposal, it only applies, well, if a person has a 30-year sentence, then they'll be considered at 20 years, but say if they had a 30-year sentence according to the language in the Juvenile Parole Act, they'll be considered at 15. Not to say that they will be released, but just taking into consideration their young age, they'll be considered at 20 years and or 50%, whichever is less.
And
So-
I think I need to defer that question to the
Okay,
chairman as,
okay.
as just the author of the bill. Or you,
If you have an answer, you're welcome to answer.
Yeah.
I mean, as far as why that provision, I think this was just the request that came from previous years.
Based on Miller
Mhm.
versus Alabama.
Yeah.
I think my answer to the question would be, certainly I want to bring us into compliance with the Supreme Court precedents
Mhm.
that we're required to be under. On the other hand, we are talking about people who have killed somebody. So I'm not, too anxious to make it super easy to get out, but that would be my answer to that.
And may I respond, Mr. Chairman?
Sure.
And so basically the actual effect of the 20%, 20 years and or 50%, whichever is less, it applies for all sentences that are 40 years or higher. So if you can imagine, if you were a juvenile and you were 15 and you got a 40-year sentence, then the 20 years and or 50% will make you eligible for parole, not release. Make you eligible for parole after 20 years. This language would be applicable to that situation, but also the language I'm proposing also would be applicable, but it only would really make practical sense for all sentences 40 years or more. So I think when you look at if a circuit court judge, Mr. Chairman, and members of the committee sentences a juvenile in light of Miller, Montgomery, and all of the cases to a term of years more than 40 years, arguably you can say that's really is a life sentence. So I think that I'm asking you if you will consider it. I think it doesn't hurt the substance of the bill. It's just will.
Certainly is. I'm sure this is not going straight to the governor's
Okay,
desk. So
okay,
as
okay.
we move along, if you want to continue
Yep.
talking about it.
So that'll be my amendment at the appropriate time.
Okay.
Yeah.
I think Senator Barnett has an amendment he asked for. If you'll go ahead and state your amendment, Senator Barnett.
Thank you, Mr. Chairman. And my amendment, Mr. Chairman, comes from concern that I've heard from multiple individuals starting probably around May of last year up until today, as a matter of fact, that will be strongly in opposition of this bill if it goes like it is. So my amendment would say that this bill would apply to those juvenile offenders who, at the time of sentence, I hope I get this right, did not commit multiple violent crimes at the time of their sentence or conviction. So I'm sure legal can address them and can fix that like this. But if it's multiple at the time, violent offenses.
So you're talking about the Luca Woodard type example
Exactly.
in Pearl.
Yes.
So you would want him or persons like that excluded from this.
Yes.
All right, you've heard the amendment. Questions for the author of the amendment? Senator Thompson?
Mr. Chairman, I think that what we're trying to do with this bill, and my DA provided me with a similar bill that I introduced earlier this year. We're just trying to get in conformance with Miller. And I think if we get down too far in the weeds on it applies here but doesn't apply here, we may run the risk of not being in compliance with that Supreme Court precedent. So I'm not opposed to the amendment. I just want to have time to research whether or not it would bring this effort out of compliance with Miller.
Thank you. Senator Sparks?
Thank you, Mr. Chairman. And I think Chairman Barnett, not multiple crimes, you meant multiple victims, like actual casualties, multiple
Yes.
murders. Okay. Not that I had a murder and also along with that another felony. I just want to clarify.
Thank you. Yes.
Thank you, Senator
That makes sense.
Sparks.
All right, other questions? Someone, Senator Jackson?
Would this bill make it retroactive?
Yes.
Yes, sir.
Thank you.
Yes, sir. Great question. I'm glad we got that answer. Okay, other questions for the author of this amendment, Chairman Barnett? If not, you've heard the amendment. All in favor say aye. Any opposed, nay. The ayes have it. All right, Senator Simmons, did you wish to offer an amendment as well?
Yes,
You
Mr.
are
Chairman.
recognized.
Thank you. I just wanted to add the language that was been drafted in both chambers, the House and the Senate, regarding starting on line 354 to say, the end of 353 to say at least 20 years and or 50%, whichever is less.
Okay, did you get that? All right, you've heard the amendment. Any questions for the author of this amendment?
And
And you're allowed to speak on it.
yep, and just to speak on the amendment, Mr. Chairman and members of the committee, the operative word is at the very beginning of 353, which is May. We are only creating parole eligibility. At no point in time does it guarantee release. And so these are juveniles we are talking about. And so it doesn't hurt the original language. It's just the original language says it's 20 years, and I'm just saying 20 years or 50% of the sentence, whichever is less, that the person may be considered. But it's up to the parole board to take all factors into considerations with the victims, the DA, and to make a determination on whether or not that juvenile has been rehabilitated and should be released.
So to give an example, just because I'm better with examples than I am sometimes with just reading it. So if some teenager, 15-year-old, rapes and kills somebody and they're sentenced to 50 years, in your amendment, how does that differ than what it would be without your amendment?
Without the amendment, they will be without the amendment, they 15 years old.
Mm-hmm.
The judge sentences him or her to 50 years. They supposed to be there until they turn 65.
Okay.
Without the amendment, at the age of 35, they could be considered for parole. No guarantee for release.
With the amendment?
Without the amendment.
Okay.
Without the amendment. Without the amendment, because it says 20 years. Without the amendment, 20 years, at least 20 years, you're eligible for parole. So at the age of 35, which is 20 years into a 50-year sentence, they could be considered for parole because they're juvenile.
Mm-hmm.
With the amendment, 50% of a 50-year sentence is 25 years.
Right.
So 25 years from the age of 15 is 40. So in this particular case, it works the opposite way. The 20 years is less than the 50% sentence.
But you're saying whichever is less.
Whichever is less.
The amendment would only affect sentences less than 40 years.
Less than 40 years.
If you were sentenced to 39 years and you get out 6 months earlier.
That's right. But not get out. Not get out.
May,
be considered. Be
That's
considered.
correct. May be
release.
considered eligible.
Okay.
Because the parole board may say this juvenile has been acting up in the air. He has not been rehabilitated. We're not going to release him. But this law basically says you can't even consider him for release until 20 years, or with the amendment and or 50% of the sentence, whichever is less. So I think it's a good amendment.
All right.
Yeah.
Senator Hill.
So if the judge sentenced them to 15 years, with this amendment, they could get out in age.
7.5, they can be considered.
7.5, they could be considered. The judge sentenced them for 15 years.
That's correct.
Or if the judge sentenced them for 20 years, they could be considered in a little less than 10 years.
That's correct.
With your amendment.
Yes.
Otherwise, they have to serve 20 years.
Yes, but keep in mind, Senator Hill, if the judge is sentencing a juvenile to 15 years or 20 years, with the DA who is elected representing the state, there's a set of facts that will suggest and support the reason why that sentence is 15 years compared to 40.
I want to give an example, if I may.
Sure.
Okay.
You're recognized.
A girl I graduated high school with was murdered by her husband in her home. a couple of years. Actually, my first anniversary, I went to her funeral. She was stabbed to death, premeditated with a butcher knife. It rolled up the blade of the knife where it went through her. He left her with a dead baby, with the baby, with her dead body. And I'm 55 years old, and he was probably 22, 23, 24 when that happened. He's been out over 10 years. He's 15 years. He's been out a long time on that type of crime. And he was an adult. So, you know, I just don't know. Judges vary, you know, in what they're going to sentence people and how they're going to let them out. But do they say crime of passion people are not as dangerous? I don't know. But that's just one example that I would have never thought that somebody that committed a crime and had it premeditated like that and left the baby with the dead body, that they would be out in less than 20 years.
Okay. All right. Other questions for the author of the amendment, Senator Simmons? All right. You've heard the amendment. If you're in favor of the amendment, say aye. Aye. You're opposed to the amendment, say nay. The ayes have it. All right. Any other questions on this bill? If not, Vice Chairman for a motion.
Yeah, Title 52 passed, committee sub as amended.
Committee sub, yeah. All right. You've heard the motion. All in favor, say aye. Aye. Any opposed, nay. The ayes have it. Awesome. Thank you so much. All right. 2119 is the pseudoephedrine bill that we have passed, actually, I think maybe once before, maybe last year. I will try to explain this one. It basically goes to the issue that if some of you, like Senator Jackson, was here maybe 10, 15 years ago when there was this big meth problem around the state and around the country. And in response to that, we in the legislature and many legislatures across the country passed a law that said in order to purchase any product with pseudoephedrine or epinephrine, like Sudafed, for instance, at the time, you had to get a prescription from your doctor or nurse practitioner or some provider in order to then go to the local store and purchase, a pharmacy or, you know, whatever store you're going to, and purchase Sudafed. And it was very effective. Our law enforcement folks at MDN and others said that that was a great thing, and the number of meth labs in the state went down significantly. So the law was a success. But as with everything in technology, things change. And all other states, I think, with exception, maybe hope of one or two others in the country, I think, or we may be the last one, I'm not sure. But almost every state in the country has now acknowledged that our meth manufacturers across the state and country use other products now that are more effective than the pseudoephedrine is. So where we basically are is we're still penalizing law-abiding citizens like myself and others that use Sudafed to treat allergies and things like that we have in South Mississippi and all Mississippi, I guess. And the drug manufacturers are still getting their hands on other products to make the crystal meth. And of course, there's an influx of Mexican meth, apparently, that is now flooding the market too. So this bill would then remove the requirement that we had placed to get a prescription for Sudafed or other like products. It will still remain behind the counter, and there will still be a computer system called an NPLEX that our pharmacies and other retailers that have these drugs will have to keep a log of who's buying this. And there is a limit. If you look on lines 13 through 20, there's still a limit as to how much you can legally purchase. It's either 3.6 grams per day and not more than 7 2/10 grams per 30-day or a monthly period. So again, we still want to keep up with who's purchasing in case they still want to use the old meth making methods of using the Sudafed. So our law enforcement friends can make sure they're not just going from pharmacy to pharmacy to pharmacy and buying the legal limits each month and, you know, stockpiling the stuff. So that's mainly what the bill does. It also puts a 2-year repealer in. And the only other thing I'm aware this current version of the bill does, which may change as we go forward, we're looking into it, is there was an amendment placed in the Drug Policy Committee about a product that's a cough syrup that has codeine in it that would also place it behind the counter because apparently there's some evidence that people are now abusing this drug as well in a like manner. So buying a bunch of cough syrup and chugging it, I guess. So at any rate, we're putting that under the current wording behind the counter. It would be kept up with the Implex, but still no prescription requirement. Now, there has been some thought that that would be something Implex could not handle, and if that's the case, we may have to take this out as we move forward in the process. But that's the current status of the bill as it's before you in the committee substitute. So with that explanation, I'll try to take any questions. Yes, Senator Turner Ford.
Thank you, Mr. Chairman. I just didn't understand what you said. What substance is this in the cough syrup?
It's codeine.
Codeine?
Yes, ma'am. I'm sorry.
Thank you.
This mask is kind of muffles everything. Senator McCon.
Oh, thank you, Mr. Chairman. The question I've got, is there a reason we're waiting for 2022 to institute this?
To institute, well, the repealer says we'll just look at it again in 2022. Oh, it's effective in 2022? Okay. Is there a reason for that, Hope?
January is fine.
Okay.
I'm sure to get it in the system.
Yeah, I think providing the Implex products to all the pharmacies is going to take a little bit of time, the software and whatnot. Okay, good question though. Senator Sparks.
Thank you, Mr. Chairman. In rural Northeast Mississippi, we had a lot of problem with the methamphetamine, and I think, as you stated, the law did stop the manufacture, it didn't stop the use.
Sure.
We've seen the issue across the border. It's literally an economic issue, supply and demand. I do appreciate the Implex system, which is going to be a little more helpful than what it was prior, and that it's behind the counter as well as the 2-year repealer. One thing I do think we need to consider is if we begin to see it again, there was federal money to clean up the meth houses because there is a hazmat issue, other issues that go with it. And I just wanted to make sure the committee understands that. Is the expectation that we won't see the return of it as heavy as we did in the past?
Yes, sir. That is certainly the hope and the expectation. Other states that have done away with this requirement have not, the information provided to me, have not seen a resurgence of the meth labs. I think unfortunately what you're seeing is plenty of supply from Mexico, so there's not really a need for meth houses like you saw, but there's still plenty of meth. I don't think we should fool ourselves. But I think what this bill is trying to acknowledge is that they're no longer using the old cooking ingredients of Sudafed, and so why penalize our law-abiding citizens by making them spend extra money to go get a prescription for something that could help with their allergies.
Thank you, Mr. Chairman.
Thank you, sir. Chairman Wiggins would like to speak.
Thank you, Mr. Chairman, and I appreciate you letting me speak on this bill. I think many know that I've been adamantly opposed to this, and just like some of y'all or some who were here in the legislature, I was in the DA's office at the time, and I stood before I stood before community members, and I held up a photo where a double wide exploded into flames, and out in the yard was a tricycle where that child was almost killed by an exploding meth lab. So it's been hard for me to come around on this. That being said, the Implex that's in this bill and the people that have met with me have gotten me to understand that we're in a different place now than we were. Just like the chairman said, and I respect what he said, that the meth labs have gone down. In fact, they basically in a lot of places have gone non-existent. At the time I was in the DA's office, and I'm not making this about me, George County was the meth capital of certainly the Southeast.
You mean it was over Pearl River?
Yeah, actually. You had people making meth and exploding meth labs, and you cannot make meth without ephedrine and pseudoephedrine. And this law, the MBN went before Congress and testified the effect of this law, and it was successful. So I've been reluctant to do this, and I've told and I'm going to stay by this. I've told when people met with me that these companies, we didn't need that law if the companies would have taken responsibility for themselves. And that's a fact. And I will say this, Mr. Chairman, that if it comes back and we end up in the same situation, I will be the first one to file some kind of bill on this, because these companies could have avoided it and out of sheer profit let it go on where children were dying and people's families were being destroyed. And I do agree, based on what I know, that due to the Mexican cartels and all that, they flooded the market and it's still there. I get that, but you're not seeing the meth labs that were there. And I do believe that there does come a time that a law that was passed is maybe no longer needed. And I credit the companies for taking the responsibility to this point and doing the inflex system. And also, one of the keys for me has been that you can allow law enforcement to tap into that, because as I've explained, people don't know what smurfing is, but they would go from place to place and store to store buying the pills and doing that. And so my understanding is that can no longer be the case, or it's tracked. So I think the accountability measures have put in. And so I'm voting for the bill, and I appreciate the people who've done that. Like Senator Sparks says, law enforcement is not thrilled, but they also recognize, the ones I've talked to, that it's not what it once was. And, I do think that the companies share some responsibility. It sounds like they've gotten there, but it could have been avoided back then, but it wasn't being done back then. And we had people losing their lives and addiction going on. So, Mr. Chairman, thank you for allowing me to speak on the bill. I think this is a watershed moment in Mississippi because of where we were. But we can't forget what was going on. So I think this is, and the 2-year repealer, I think, is really good, because we can come back and again, if the inflex system is not working, then we can repeal this bill. So thank you, Mr. Chairman, for allowing me to speak.
Thank you for your leadership on that bill. It's very important. All right. Any other questions? All right. For a motion, Vice Chairman?
Yeah, title sufficient to pass.
You heard the motion. All in favor say aye.
Aye.
Any opposed, nay? The ayes have it. Thank you so much. All right. Senate Bill 2121. We'll turn this program over to Vice Chairman England.
Thank you, Mr. Chairman. Fellow committee members, this bill is what is commonly referred to here and known by us as the revenge porn bill. What this does, it creates a criminal violation for the non-consensual disclosure of visual material containing intimate parts or sexual conduct of another person. I'm going to give you a little bit of just overview here before I get into the bill. And when I say non-consensual disclosure, I want to point out that just having material is not criminalized. It is the disclosure of the material. Revenge porn is a term that's used to describe the distribution of sexually explicit images or video of individuals without permission of the image or video's subject, usually to cause embarrassment or stress, like after a breakup or anything of that matter. This bill did pass through committee and pass on the floor of the Senate in 2019. It's back before us now. 46 other states do have revenge porn legislation. They've enacted that. Wyoming, South Carolina, and Massachusetts join Mississippi as also not having this yet. This legislation is modeled after Texas, and a few portions are modeled after the Georgia law. So I guess the laboratories of democracy have kind of been through this a little bit, and here we are, in my opinion, a little bit late to the game, but we're getting in it and hopefully going to be able to get this passed today. This legislation would arm prosecutors with means that they don't have right now. This conduct is happening in Mississippi, and currently our law does not provide a path for prosecution for revenge porn. that being said, let's get into the bill. And I want to let you know that I do have before me a committee substitute that I'm going to be discussing. And in the end, the motion we've made to accept the committee substitution. The primary reason for having the substitute, you don't have it before you, I don't believe. So I'm just going to read these portions to you. In section 1, there are a couple of new definitions added. The first one is information content provider, which means any person or entity that is responsible in whole or in part for the creation or development provided through the internet or any other interactive computer service. The second definition is interactive computer service, which means any information service, system, or access software provider that provides or enables computer access by multiple users to a computer server, including specifically a service or system that provides access to the internet. This also includes services operated by libraries or educational institutions. I know I went over that quickly, but you don't have it before me, and I just wanted to put that at your attention because it is not before you. We'll get to that. The reason we have those definitions in here in section 2, it's a new, which you also don't have, is a new section 2, subparagraph 6, but I'll discuss that when we get to it.
All right, Mr. Howell's going to check on getting copies for everybody.
Okay.
Continue.
Okay, thank you. Yes, okay. I'll keep going on, and hopefully we'll have those by the time we have, if we have any questions. Section 1, as usual, outlines the definitions, some of which I just discussed. I want to jump straight on into Section 2, which is the actual meat of this bill. It creates the offenses provided under this. The first offense that's outlined, I'll just go through the main factors here. So in order to be convicted of this crime, you would have to meet these factors. First, without the effective consent of the depicted person and with the intent to harm, and that's important, I want to point out, because in Texas they had a constitutional challenge that involved intent. So that we do have that in here and don't expect that to have to undergo a similar challenge, which is a great thing for us. Without the effective consent of the depicted person and with the intent to harm, the offender discloses visual material of the intimate parts of the depicted person's intimate parts exposed or engaged in sexual conduct. If you look back at your definitions, we do have intimate parts defined. It means the naked genitals, pubic area, anus, buttocks, or female nipple of a person. So that's the substance of what this what would be depicted of the person. At the time of the disclosure, the offender then has to know or have reason to believe that the material was provided or obtained and that the person depicted had a reasonable expectation that that material would remain private. The next factor is the disclosure of the visual material does cause harm to the depicted person. And finally, the disclosure of the visual material reveals the identity of the depicted person. That's the first way to commit an offense. The second portion outlines that just threatening to disclose the material is also an offense. When it's done so to obtain a benefit, so basically extortion. So if you threaten to disclose this in return, or you threatened to disclose it and you said you wouldn't in return for not making the disclosure, you perform a sexual act or receive a sexual act. I don't know if that's the proper way to put that, but that's what that one does. If the offender promotes the visual material described in subsection 1, that's also an offense on their, like on an internet website or some other forum. And number 4 of section 2 mentions that it is not a defense to prosecution if the material was created or consented to by the person, or if it was voluntarily transmitted to the person. So obviously, I think that speaks for itself. Now, we do have an affirmative defense that would allow people to disclose this material if it is under lawful and common practices for law enforcement or medical treatment, or if it's to report unlawful material. In other words, if you send that in, you're not going to be guilty of this crime that we're creating here. Also, it is a defense if the disclosure or promotion consists of the visual material depicted the action in a public or commercial setting. So if you If the video shows something that happened in public, or if it's part of some commercial venture, that's not what we're doing. We're not outlining pornography here. We're just outlawing revenge porn. If you look at section 6 or section 2, subparagraph 6, that is where the first definitions came in, and Ms. Pat's got these for us now, so we'll be able to look at that. But I'll just read it again because you're just now getting it. It says, no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider for an action brought under this act, unless the provider or user of an interactive computer service is responsible in whole or in part for the creation or development of the information provided. If we all know of platforms on the internet like YouTube and other things, if something like this ends up on YouTube or on Facebook or on some other platform that's provided, that platform is not guilty of this crime. Okay, now the person who does cause that to be published on that site could be guilty, but not the actual platform provider, the internet service provider, or the internet provider. Let's see, that's basically the meat of the bill. If you have a first offense under this bill, it's a misdemeanor. A second offense is a felony, except if you commit a revenge porn act for the purpose of profit for financial gain, it is automatically a felony. Subparagraph 8 is basically a long arm statute for jurisdiction purposes, and this does come into play. And what that does is, even if it happens within or outside of the state, if the person depicted is an individual that resides in Mississippi, the prosecutors can bring charges in Mississippi. Or if the action happens within Mississippi, then charges can be brought. So that's just kind of a jurisdictional long arm portion of the statute. I think that basically is the bill pretty much in its entirety. I do also want to point out that when we think of revenge porn, we typically think of someone who broke up with somebody and they had an intimate photo or something of their ex-spouse or lover, and they put that out on the internet. But it also happens in instances of human trafficking. And so if someone is involved in human trafficking and they're eventually rescued from that, they may have videos or pictures of them that were taken while they were involved in human trafficking. And so every time those pictures or videos would come up, it's like a new crime all over again. People have to, they're again victims. And so this is an effort to stop that. And I think that's a very important thing, in my opinion, to point out. Another thing that I would point out, so obviously the first offense is misdemeanor, second offense is a felony. If you do conviction under this particular statute, if you are convicted of this, you do not have to register as a sex offender. I did want to point that out. I think I've covered everything I know to cover in this, but if not, I'm glad to answer questions. And what I'm even more glad to do is to turn over those questions to the guys in the AG office and my friend Anna Suchman back here.
I did want to, yes, thank you for recognizing them. If you guys and lady will raise your hands. They've been working really hard on this for a couple of years, and General Fitch is also very supportive, I understand. So thank y'all for being here. And thank you, Chairman England, for presenting that. One question that people, I guess, have raised and asked of me, and I think you probably covered it, but just to be sure. So what protection is there in here for a person who they made this video or this depiction together consensually, and then later on someone posts it and the victim then says, oh, well, I never consented to that. I didn't want it out there. This is horrible. And, trying to get the person in trouble. Is there any sort of protection in that situation?
Yes, Mr. Chairman. So it's actually not a defense if the material was consented to early on. I think that the ladies and gentlemen in the back can provide additional information if necessary, but it doesn't matter if it's consented to initially, unless it was for profit in a commercial setting or something like that.
But what if it was consented to by both parties to put on social media? Like they were both in on posting this, which I can't imagine someone wanting to do that, but people do crazy things. So we make a sex tape, we put it out there on the internet together, and then because, now I'm now embarrassed, someone said something about it, so I pretend that I really didn't consent to that, and then the other party is now subject to this law.
Yeah, that is tough to imagine. I can imagine it, but it is tough for a lot of people, I imagine, to think of something like that. But if you look at lines 53 through 54 under the where the person commits an offense, it says that if the act, the depicted person had a reasonable expectation that the visual material would remain private, then that is a factor there. So if something is created within the relationship and within the spirit of the relationship, and it was to remain private for the enjoyment of the two individuals or however many individuals involved, then that so that is covered there in the bill.
Perfect. All right, Senator Turner Ford.
Thank you, Mr. Chairman. Looking at section 2, the word that I see there, it says that appears to me to be operative is disclose. But unless I missed it, this can occur between two people. It can be disclosed to one person, and that can give rise to this criminal offense. It does not have to be widely publicized. Is that required? Is it required that it be publicized? Or if the material is given to just one other person, it invokes this crime?
Well, it's disclosure outside. So this, I guess the spirit of the bill is just like if you commit libel or slander, as long as you mention it to one other third party, that's an offense. And I believe that's what's intended when it says disclosure. But I would like to ask for input from our colleagues, or the colleagues back here from the Attorney General's office, if that's okay. Kyle, if you would like to, would you step up to a microphone for us, please?
Thank you, Mr. Chairman, and the committee. I would also note that one of the requirements is that there be harm. And so if someone gives a picture of myself, I don't think I could be harmed by that also. So I think that's kind of one element of it also. There has to be an intent to harm and then actual harm.
I think my question was, let's just say I give it to one of my friends, and that is to one individual. It has not been publicized, and whoever is offended by this can say, well, this caused me whatever, and I cried last night. How do we prove that this has occurred? Couldn't we potentially be in a situation where we're accusing someone of a crime and it may or may not have happened?
Do you understand the question, Kyle?
I'm not sure that I do. So is your question, Senator, about providing it to a third party, or only between the purported offender and the subject of the photo or video?
I would say a third party. And okay. I guess my question is it actionable if this material has just been disclosed or provided to just one other person, or does it require some sort of publication?
I think that even being provided to one other person, I think for an example, if I only provide it to the subject's employer, that would only be one person, but it could certainly cause harm and be provided to that person with the intent to cause the harm. So I don't think it has to be widely disseminated in order to trigger the statute. I think so long as you publish, or you provide rather, to a third party, while meeting all of the other elements, certainly, I think that would be accurate.
Thank you. Thank you.
Yes, Senator Jackson.
Thank you, Mr. Chairman. My question is, if the material is misplaced and someone finds it and put on the airway or whatever, then are they going to be prosecuted?
Well, there may be other laws involving the finding of material, but I still think you do have the intent. If you had the intent to harm and it depicts the other person, you're going to have to meet those requirements. And this isn't going to catch all instances. And I would say if someone found this material and put it on the internet, even if it wasn't quote unquote revenge porn, they've caused another person to, they've disclosed the material. So I would think that probably would meet the criteria. It would depend on the prosecutors as to whether or not they could fit that, have the facts fit the crime. But if they could, yes, I believe that would be an instance where it would work.
Thank you.
All right, Senator Super.
Thank you, Mr. Chairman. I just have a question.
Sure.
So one of my concerns is, what do we mean by effective consent, like in line 45? I mean, you mean written consent? I don't know. I mean, I've dealt with quite a few of these cases. I've dealt with in city courts and circuit courts, and one of the big questions I always had was, she or he said I could show this to my buddy. Then the buddy puts it up on the internet. I mean, what do we mean by consent?
Well, I think that's a good question, but I think that's a good question for the defense attorney to argue in court over that. And so we're not we're not going to deny due process, and you could obviously argue what effective consent and whether that is met in a defense setting. So I think it's a good question, but I think it's for the courtroom.
Well, but then that goes back to like line 77 that says, or 75 through 77, it's not a defense to prosecution under this section. Part A says created or consented to the creation of the visual material.
Well, that's creation, so that's not the depiction. So if you consent to the creation of the material, that's what that outlines. That subsection, subparagraph 4. Does that answer your question?
Not really, but
all right. I mean, I'm happy to continue if I
think what he's trying to say is that you can consent to the creation of a particular item and not consent to it being made public to anybody other than the two parties that you created it with.
Well, I understand that.
Yeah.
I think it's kind of vague as far as just the consent part.
Gotcha. All right, Senator Hill, had a question? Chairman Hill, rather.
I think that we pretty much all know that naked picture disclosure of somebody without their permission is not going to be beneficial to the person who's the subject of the photos. It's going to create some kind of harm unless they're engaging in some kind of commercial contract for this. So, you always have he said, she said. Anybody can go to justice court right now and press any kind of charges that they want to. They can get a judge to sign it, whether it's true or not. But I think that this is used pretty widely. Would you not agree? That
Yes.
This is used for blackmail, extortion, a lot of things against a victim when they have this material.
Senator, I would agree.
Created, whether it's consensual creation or not, how it becomes used is what we're actually dealing with here.
That's correct.
Correct.
It does cause very real
and
harm.
that's what I wanted you to clarify.
That's right.
And I think the chairman clarified that as well. But just because you consent to let your boyfriend take a naked picture or a video of you does not mean, or even your girlfriend taking a picture of you or whatever nowadays, taking a picture of whomever, that does not, consensual creation is not the same as consensual
Disclosure.
release of the material. And that was the point I was just trying to make.
That's right. Thank you, Senator.
Senator McCon.
Thank you, Mr. Chairman. My question is probably more of proof, and it may be getting in the weeds a little bit, but it's a concern I would have. In our digital world, the stuff's sitting on your laptop, and your laptop or your system gets hacked, and then a while later, let's just say 3 months down the road, it appears on the internet. Now we're in a position of having to prove your innocence, that you have to prove that you're innocent of disseminating and prove that you were hacked, even though you may not be able to find the actor. Do I make any sense there, Mr. Chairman, to the route I'm going there? Have we considered that? Do you understand where I'm going with it with the AG's office?
And if I can, Kyle, please come on up, Kyle. But I just wanted to point out that the section 2, subparagraph 1B, mentions that at the time of disclosure, the defender knows or has reason to believe that the visual materials obtained by the offender are created under circumstances in which the depicted person had a reasonable expectation that the visual material would remain private. I think that a prosecutor may have a difficult time reaching that, but still they're going to make the argument and they're going to let the facts fall where they may. It would be my answer. But Kyle,
And I would agree with Senator England. There's not an express kind of consideration for that, except for to the extent that you also have to prove that they had the intent to harm at the time that the material was disseminated. So it's kind of it's not a strict liability. It's out there. You took it. You also have to prove that intent to harm.
Well, to come back to that point, the intent to harm, as Senator Hill mentioned, is essentially built in. So now there's an intent to harm. If that gets disseminated out there to someone, I mean, from my perspective, sitting out there, I would feel like that's kind of already built in. There's not an expectation. You've got an inappropriate picture that gets put on the internet. The harm happens. As far as that intent, from my prosecutor side going, I would say it's kind of there. I guess I'm good with the bill. That's just something I see sitting out there that I feel like is going to be litigated in court, and I hate for someone to have to now say, hey, look, someone in Pakistan hacked my computer, and all of a sudden now it's on random sites. And everybody, it's hard to prove that sometimes.
All right. Good question. Senator Simmons,
Question, Mr. Chair.
you're recognized.
I'm just trying to put my head around this. I love the fact that it addresses some of the human trafficking concerns that we have talked about in this body over the last few years. I'm just thinking when we did human trafficking, we placed a limit on the age because we recognized in human trafficking that minors are victims and we don't want to victimize them even more by subjecting them to a criminal statute. So I was wondering, and I'm just throwing it out there, what, if any, considerations have been made to make sure we're not targeting teenagers and their conduct regarding youthful indiscretion and the dumb, stupid things teenagers do in relationships?
Right. Well, yes, if I think I can best respond to that by saying that a previous version of this bill did have language criminalizing sexting, and I think we all know what sexting is, which I would think would be what would occur between teenagers, and so that's been removed. But
we don't define person.
That's right. We don't define person in this.
And I guess another question too, Mr. Chairman and Senator England, is I have a nephew, and I understand he's a college student at Jackson State. I don't have an OnlyFans account, but I've heard a lot about these OnlyFans account, and some of them are appropriate, some of them are inappropriate. What do we do in a set of facts in light of what's being proposed? 2 college students, age 19, decide to make a sex tape, and he or she posts the tape on his or her OnlyFans account, where you can only view the OnlyFans account if you are a subscriber or a friend to that OnlyFans account page. And the sex tape is out there for 3 months. And boyfriend, girlfriend, they cool with it. Then there's a breakup. 3 months and 1 day after the breakup, now all of a sudden I'm upset about what was posted and had been posted for 3 months. How do we deal with that?
Yes. Thank you for your question, Senator Simmons. So there is a defense that if there's the disclosure or promotion is in a public or commercial setting, that is a defense. And I've heard of fans only. I'm not sure exactly what that is. I don't know if you profit off of that or if it's like something goes viral, you make money off of it, but that would be in a commercial setting. So there's a defense to that, that if you create a video with a partner and you post it on that commercial setting, or if the act is performed in public, then you are not, then that is a defense that you can raise under this bill.
Good question and good answer. And I will have to say too that, I mean, I know more and more it may be more equal as to who the victims of this are, but traditionally it's been female victims of these types of things for whatever reason. So I do appreciate that we need to be careful and make sure no one is wrongly prosecuted, but we also have to protect our female constituents to make sure that just because there's a bad breakup or whatever, that they're not shamed and humiliated in these types of things. So I think that's the genesis of this bill. Senator Simmons.
And one last question, Mr. Chairman. And there's nothing in the bill that will prohibit if the act was committed by a minor for it to be adjudicated in youth court, correct?
No, sir. That is correct. All right. You've heard the explanation of the bill, which was excellent. Thank you, Senator England. Any questions further for Senator England? If not, Senator England?
Yeah, title sufficient do pass, committee substitute.
You've heard the motion. All in favor say aye.
Aye.
Any opposed, nay? The ayes have it. Thank you so much. All right. We're moving along here. And thank you to our friends in the Attorney General's office. They actually have, I think the next bill, Senate Bill 2223, is also an AG request that we were happy to consider. So if one of you would like to come forward, whoever your designee is, to explain why and what it does, we would certainly, Kyle, appreciate hearing from you.
Thank you again, Mr. Chairman and committee. Senate Bill 2223, it does two separate things. It would allow search warrants to be obtained electronically, essentially, for certain computer crimes that are set forth in 7559, which is one of the Attorney General's enabling statutes. And really that's computer luring, cyber stalking, identity theft, computer fraud. There's just a small number of crimes there that our cyber crime division investigates and prosecutes. And I'll just go through section 1 first before I move on to the other issue that the bill does. The primary need for this bill is our office obviously investigates and prosecutes statewide. And so oftentimes if we have to go to DeSoto County or to the coast or Corinth or other areas of the state, those are certainly the extremes, but our investigators are spending an entire day or prosecutors traveling all the way up to try to catch the judge and then coming all the way back down. So this section 1 in this bill would allow our office to do this electronically. And so this is modeled after some Alabama language. And I was in here earlier today, we passed Senator Blackwell's bill that was similar to this. It was more broad. So this one's limited to those specific types of crimes that are set forth there. And I guess another difference I think between this bill and the one we took up this the committee took up this morning kind of relates to the process. And again, this was taken from some Alabama language. So to do this, essentially the individual seeking the warrant you could call or I guess Zoom or some other mechanism to be able to communicate with the judge, and you would read aloud the copy of the warrant that you've created. So the affidavit and everything else. The judge would also have a copy of it. The bill anticipates the judge kind of creating a copy as it's read aloud. I think in practice, you probably send the judge a copy and you simultaneously read through it to ensure that everything aligned. And so if the judge deemed that the warrant was worthy of being issued, that the individual seeking the warrant from their remote location would sign the judge's name. The judge would contemporaneously sign his or her name, and the original copy would be the one that the judge signed. And again, this was taken from Alabama, and Alabama's language doesn't, certainly ours only applies to a couple of specific kinds of crime. Alabama's is much more broad. And so upon applying for that, so when you first make contact with the judge and let he or she know that you're trying to obtain a warrant, you're either recorded, audio recording, or there's a court reporter there to transcribe the conversation and all of the testimony there that would serve as the basis for the warrant. And then Section 8 just says that a motion to suppress can't be granted on the basis that that the warrant was obtained electronically. And I guess the easiest thing to do is go ahead and go to Section 2. Section 2 is very straightforward. It would allow a judge to sign electronically an emergency abuse protection order. So domestic abuse protection order. So this is generally not an issue in courts that are subject to and utilize MEC, but oftentimes these emergency orders are issued in justice court or municipal court, and so there's just not a mechanism there to do an electronic signature. So this would allow that to be done. It doesn't require that the judge do that, but it would give the judge the option to electronically sign those protection orders. And I would add on Section 1 that during the pandemic, and I suppose we're still in that period, so it's kind of strange to say during the pandemic, but the Mississippi Supreme Court allowed for video conferencing. You could obtain a warrant by video conference, and so this is different than that. But the court did anticipate some type of remote access.
Okay. Any questions for Kyle on this bill? Senator Sparks.
Thank you, Mr. Chairman. A little bit more information than the warrant request this morning that we had in section, I guess, subparagraph 5, recording and certification of testimony. So the judge is going to be called. He or she has to verbally be on the phone with whoever's requesting the warrant.
That's correct.
Otherwise, you don't have a warrant.
That's correct. Or Zoom or some type of remote, but it has to be in real time, certainly.
Okay. And the statute says the judge shall, on line 41, record if he or she has a recording device. Otherwise, a longhand record shall be made. So as I read this, you either will have a recorded call or the substance of that call if, in fact, that search warrant led to a crime and an indictment, et cetera, correct?
That's correct.
So a motion to suppress being precluded absent a finding of bad faith, I would say that absent a recording or a longhand version of the conversation, I'd move to suppress that warrant.
In the absence of either one?
Well, it says shall have it, and that's my biggest concern. I don't mind using technology, but it's very important to know what was said to that judge, protect the judge for the warrant, and we're saying shall have a recording or a longhand description. I'm a little uncomfortable with you then saying you cannot move to suppress my warrant absent a finding of bad faith, because somebody may say, well, my recorder messed up, or I forgot to write it down. Well, I mean, I'm a little concerned with that language. I didn't know if there'd been much discussion on the motion to suppress portion.
There hasn't, Senator, and we certainly wouldn't. I don't think we would oppose any type of amendment that would say, in addition to bad faith, failure to comply with the statute.
And I would submit the amendment at the proper time.
I think that's an expectation. If it says shall.
I would potentially ask to strike the whole paragraph, but I certainly, I don't mind them getting the warrant, but then when you take away the right to move to suppress, apparently the triumphant's meeting behind me, so.
Okay, so lines 56 through 60, does that not address what you're talking about?
That's correct, Mr. Chairman, and I would move that we strike that if there's a motion to suppress, the judge ought to hear it and follow the law.
Yeah, and I guess and maybe the idea is that if the warrant is issued under this section, there's some thought there that it comports with the section. If it's issued under this section, that you would comply with the requirements to obtain it.
But bad faith is a really high standard. So I would, absence of finding a bad faith or failure to comply with the statute would be mine.
With respect, I may be reading the provision differently. The way I see it is it's evidence obtained pursuant to a warrant issued under this section is not subject to a motion to suppress on the ground that the circumstances were not such as to make it reasonable to dispense with a written affidavit. I think you could still make a motion to suppress that the section itself wasn't complied with, right? Or am I reading? Okay.
Well, I think that's still a judgment call, but I do agree that you've actually added a different standard. You're saying that it wasn't reasonable to dispense with a written affidavit, so that still doesn't.
It is a different standard.
Okay.
All right, so you recognize for your amendment, Senator Sparks. Would you restate it?
Yes, Mr. Chairman, I apologize. I'm trying to make sure I state it like I need to. I would move that we strike that section as amendment.
Okay.
Mr. Chairman.
All right, you've heard the motion or the amendment. Any questions for the author of the amendment? All right, seeing no questions, all in favor say aye. Aye. Any opposed, nay? The ayes have it. All right, any further questions?
Thank you, Mr. Chairman.
Thank you. Appreciate it. All right, any other questions, comments? If not, Title Special Bass Committee sub is the motion. All in favor say aye. Aye. Any opposed, nay? The ayes have it. All right. So this is the one. All right. Perfect. Let's go to Senate Bill 2282. I think that's our next one. And Senator England, I believe that's your bill.
Yes, thank you, Mr. Chairman. This is a very simple bill. It has the entire code section is there, but essentially this just raises the age of youth detention in the detention facility from 10 to the age of 12. So that's very simply what this bill does. I have looked at some research on this, and I think this is a good idea. Mainly, when you look at the crime rates among ages, the 10 and 11 year old age group is the least likely to. They had the lowest crime rates in the country. Also, I'm troubled with the incarceration of young children and the long-term effects that has. For example, they're less likely to graduate from high school. They're more likely to return to prison as adults when they're younger. And finally, research from a group in Texas actually found that it costs 3.5 times more to detain youth. So I do think this is a good bill for us at this time. It raises the age from 10 to 12. There's still other options that youth court judges have, such as counseling, diversion, and other counseling, training, mentorship programs, other things they can do. We're just seeking to raise the age on detention, and that's what this bill does.
Okay, you've heard the explanation of the bill. Questions for the author of the bill? All right, seeing none.
I would move title sufficient to pass.
All right, you've heard the motion. All in favor say aye.
Aye.
Any opposed, nay? The ayes have it. Thank you. Bless you. All right, and we're skipping the next bill because I think the language of that one is actually better suited for a bill that Chairman Wiggins has got going in a different committee. So we'll spare you that explanation of that one and go down to the last bill on the calendar, which is Senator Barnett's Senate Bill 2573. And if you need some backup from Commissioner Tyndall, I don't know if this is something that y'all are working on together or not, but you are welcome to call on him if needed. Senator Barnett, Chairman Barnett.
Thank you, Mr. Chairman. And this is a very simple bill that we have before us today. This is a bill that was created out of a peer report that involved MDOC, sheriffs, judges, DAs, and other individuals individuals as well. And what this bill does, it basically gives Mississippi law enforcement a tool that we have never had before, and that is the ability to share jail data across institutions. So whatever happens in Jasper County can now be shared easily with Tishomingo County or vice versa. And this information will be collected by the information technology system that the state already uses, so there's no money involved. And Commission and Department of Public Service, along with Commissioner Kendall, will be the database that will store all of this information. So everything will be shared amongst counties, jails, MDOC, Department of Public Service. So it's not just, where we've got individuals sitting in one location for one crime, and we don't know that they're wanted for something else on the coast. So now with this database, all information will be shared at all the times amongst all of our law enforcement agencies. And this was a bill that was asked for, like I said, by the peer task force, who was formed by MDOC, sheriffs, DAs, judges. All of them have agreed and asked if we would pass this legislation. So I'm open to any questions at this time.
And I believe the cost is non-existent. Like
The cost
ITS has said they could do this in their
Exactly.
current
Yes.
budget. Okay.
So there's no cost to the state for this.
Gotcha.
But this is something that, and you all in the past, when we have talked about criminal justice reform, I think Senator Hill has asked this question every year that I've got up to talk about criminal justice reform. How are we going to track and how are we going to keep up with these individuals? That this is the tool that we can use that at our disposal now to make sure that that's taken care of.
Great. All right. Questions by the others. Senator Hill, Chairman Hill.
I know there was Lydia Chastanow had dropped a bill that was similar to this that went to my committee, and I can't remember all the particulars, but it mentioned something about the administrative office of the courts. Is this bill taking that into consideration? Because it talked about the data. It talked about when the inmate was put in the county system, when they were moved, what their bail was, but it had something else to do with the administrative office of the courts. So
This bill encompasses those same things that you were asking for. All of the information will be shared as part of that individual's incarceration, where they was locked up, what time, what the bond was. All of those things are in this.
Okay. Well, we already have a problem now with different entities not reporting even dispositions of cases. So, you can't even track the disposition of some of the cases from what I've gone back and looked at. So what are we going to do to make sure that they put this information in? Because they're not putting the information in.
Well, this bill right here.
On a lot of these trials and dismissals and things like that. So.
Well, this bill right here will force law enforcement, regardless of what agency you are, to report.
Well, it says that statute about disposition of cases and all to report too, but they're not doing that.
This is the piece that we needed to enforce that, Senator.
Well, I hope it happens, but like I said, we're not getting
a lot of that information has not.
I mean,
yet.
no, we're not, because
I think that's the problem that Senator Barnett's bill is attempting to rectify.
Somebody's going to have to be designated as being responsible, because they're going to say, well, that's the circuit clerk's responsibility. I can see different throwing this thing around like a ball. So that's my only concern, is that we know who's supposed to be putting this in and who's responsible for it and who we're going to have to go back to whenever we find out they're still not putting it in there.
Well, I think the answer to that, Senator Hill, is the discussion that I've had with everyone is that, we have some agencies out there right now, some sheriff departments and agencies out there right now that do not mind doing what they're already know that they're supposed to do without the lawmakers having to force them to do it. But this is to make sure that those individuals out there who, like you said, say that we don't have time, that can do it and won't do it. So this forces everybody to start doing their job and to share this information so that we can better track those individuals regardless of where they're housed, regardless of what the crime for was, the bond, the whole 9 yards.
Aren't we already supposed to be sending that stuff in federally? Remember we passed something to comply with the federal requirements for federal law enforcement funds that we were.
Not sure about that, but I do know that in some instances, some of the sheriff's departments, maybe in the rural counties or counties with less resources, are doing it by paper logs, and that's obviously just
some
not
of the
getting it into
the
real time.
entities said that they didn't have the financial means to be able to
Right.
report into this federal database. But I'm not opposed to this at all. I'm just concerned about how we're going to get it done.
Right.
Even though we put in statute, because there's a lot of things we put in statute that aren't done.
All right, Senator Turner Ford, Chairman Turner Ford.
Thank you, Mr. Chairman. My question is, so we're saying that there are no costs associated with this. Will this be cloud-based, or are there any equipment requirements that would be required by counties in order to access this program?
No, because ITS has informed me that they will confer this information with everyone so that they would know where to upload this, and they have the manpower and the technology to be able to handle those things. So there's no cost at all to the individuals uploading this information and getting it and sharing this information. So no, ma'am, there's not a cost.
And then my next question would be, I think someone alluded to it a moment ago about these reporting requirements that the counties have, these meal logs. Is there any plan to maybe alleviate some of those responsibilities and whatever the census data that they're having to report?
There is, and that's why this study was done. I think this was like a 2-year study that was done, and it was agreed upon, like I said, by Police Chiefs Association, the Sheriff's Association, the DAs, the judges, so everyone knows what was agreed upon for this to become an effective piece of legislation. So yes, they do understand the process and what's being done with this piece of legislation.
Thank you.
All right, Senator Jackson.
Thank you, Mr. Chairman. I have a friendly amendment if Commissioner Tiller agree with it. And it reads that the Department of Public Safety shall enforce the compliance of Senate Bill 2573.
I think he's jerking your chain there, Commissioner.
You say we have additional funding?
All right, Senator Simmons.
I think I have a friendly amendment, Mr. Chairman.
Okay, you're recognized.
So first of all, let me say I think it's a great bill. I've been sponsoring this bill for a number of years. But I'm looking at line 78 where it has the number of individuals detained for a new offense or delinquent act. And so anytime I hear delinquent act, I think about youth court. And then when I look at line 99 where it has the information that must be actually maintained for each detainee, it starts off with name, sex, race, and date of birth. So my amendment would be on line 99 for it to keep this, for it to maintain that we still will report the name, sex, race, and date of birth. And the additional language would say, except only use initials in the event that the detainee is a minor. Like we do right now, even in our court cases. I know you're trying to actually account for the data, but do we want the name of minors actually reported and listed? I guess that's the question.
I'm okay with that.
All right, Senator Barnett.
Yeah.
Or Commissioner Tyndall, would you like to speak to that?
If you don't mind, and as it is an indictment, usually it's just the initials
That's right.
that are provided. So I believe it would track whatever would be in the indictment, which would be the initials of the minors, and not full disclosure. And if we were to receive that, obviously that would be redacted for any sort of public dissemination.
I just, if it was a delinquent act in Harrison County and my sheriff in Washington County accessed the data, I just don't think my sheriff or any law enforcement or my DA in Washington County should even know the name of that minor in Harrison County. I mean, that's my point. I mean,
That's right, and I believe under the Youth Court Act, they can't submit that information anyway.
That's correct. I just saw when I saw the delinquent act on line 7-8, I just. So.
Okay, Senator Barnett, would you like to respond to Senator Simmons?
I think based on what, I mean, I'm okay with the amendment for the protection of the youth. I'm okay with that.
All right, if you'll state your amendment again, Senator Simmons.
Just add on line 99 that after birth, if we just put it, except use the initials in case of a minor.
Okay.
Yeah. Still provide the sex, the race, and the date of birth, because I know we're just doing data collection, but
right.
Just don't put Derek Simmons.
Okay. You've heard the amendment. Any questions for the author of the amendment? If not, all in favor say aye.
Aye.
Any opposed, nay? The ayes have it. All right. Any other questions, comments, amendments, Senator Thompson?
Thank you, Mr. Chairman. I noticed in section 4, I understand we're amending an existing statute. In section 4, line 162, you guys have a provision there that there's going to be a report authored by September 1, 2021. Would that report include what we're contemplating here, this new legislation, or should we have a second reporting deadline for whether or not this new reporting system is going to work?
I believe the report contemplated here is goes to the question that Chairman Turner Ford had asked, in that the ITS folks are supposed to look into all this and see what all the various sheriff's departments are using, and to see if it needs to be cloud-based, if it needs to be server-based, what type of system could best accomplish everything we're telling them they've got to accomplish in this. So that's the report, as I understand it, they're talking about delivering to.
I think the intent here is, Senator Thomas, is that we don't wait until 2022 to find out how effective this is. If this passes upon July of 2021, then ITS is ready to report to us or make a peer report as soon as possible as to how effective what we're doing is working early on, and not rather sooner than later, I guess is what I'm saying.
So it's possible that September 1, 21 report would include this centralized database that we're contemplating, that's in this bill.
Yes.
And you don't need a second reporting deadline to capture the effects of this.
Well, we don't want to say, I mean, I don't understand why we need two deadlines. I think if the sooner we get started, the better, so that when we get our annual peer reports, then we know exactly where we are with this piece of legislation.
Okay, so even if we don't add a second reporting deadline here, your 22 peer report would include this centralized database?
Yes.
Okay.
Good question.
Thank you.
Yes, sir. Any other questions, comments, amendments? All right, Senator Barnett for a motion.
Yes, Title Fisher DuPage
Committee sub.
Committee sub.
You've heard the motion. All in favor say aye.
Aye.
Any opposed, nay? The ayes have it. All right. Senator England.
Yes, Mr. Chairman, I'd like to make a motion that we take the motion to reconsider off the table, that we essentially reconsider SB number 2283, the Freedom of Roadway Act.
Okay. You have heard the motion. All in favor say aye.
Aye.
Any opposed, nay? I believe the ayes have it. Okay, the ayes have it. So we're back to you, Senator England.
Thank you, Chairman. Chairman Fillingame, what I propose we do here on this, after some discussion from earlier, I would like to propose an amendment, and I will go ahead and state that amendment if that's
Please,
proper this
yes.
time. Okay. Under section 2 and line 8, we are striking the words public street, highway, or road, and instead we're going to have the statements, we're going to have the phrase state, highway, or federal interstate. And I spoke with legal earlier with Ethan, and I wanted to make sure, I don't know the language that we'll need for this, but I want to make sure that this includes state highways and interstate, federal interstates that are within the boundaries of a municipality. And I spoke with Senator McMahon on this. I believe we have his support as the author on this amendment. And if I can just explain one step further why we why I like this amendment, what Senator Turner Ford mentioned earlier really struck me, and this kind of takes that option off the table where if we have something organic happen here at the Capitol and we're shutting down streets here locally, and we also had other concerns with Senator Barnett and myself about the smaller streets and town roads. So this alleviates that, and with this amendment, if it's accepted by the committee, I'm good with this bill going forward with the amendment.
Okay, you've heard the amendment. Are there questions? Senator Hill?
I think when you were speaking, you talked about going through a municipality, but we need to cover state highways and interstates, whether they're in a municipality or not. We don't need them blocked anywhere.
That's right.
Is that
What I meant was including those within. I just want to
Okay,
make sure that there's
okay.
not some jurisdictional issue that
Okay.
I'm leaving out. So it would read including those within municipalities.
okay?
All right, so Chairman Turner Ford.
Thank you, Mr. Chair. The statute that I referenced earlier, I had it jotted down somewhere and I don't have it now. But if it's already illegal to obstruct a public highway, then why do we need this bill?
Senator England, would you like to?
Yeah, no, I think that's a good question, but I would just say that this bill, it's now that we've drawn it in, it's very exact. I think the intent of the bill is pretty clear at this point on what we're doing, and I would support this bill. But I do think you have a good question.
All right, we haven't adopted the amendment yet, have we?
I don't
All
think
right.
so.
Any questions specific to the amendment? If not, you've heard the amendment. All those in favor of the amendment say aye.
Aye.
Any opposed to the amendment say no.
No.
I believe the ayes have it. The ayes have it. All right, so we're back on the bill as it currently is constituted or amended. So back to Senator Turner Ford's question.
There's still are we under the impression that because the example that was used earlier was the donuts or whatever that were made in the highway or the interstate. Are we under the impression that could not be prosecuted, that there are no existing statutes?
I don't think so. Senator McMahon, you're the author of the bill. Would you like to come and answer these questions?
Thank you.
Yes, sir.
Senator Turner, it's my understanding the fines are much inferior to this fine of $1,500. That the fines are around $300 currently.
So what about this language about the unpermitted protest? How does that factor into the examples that have been given for needing this statute? I don't think that an unpermitted protest has anything to do with a car obstructing I-50 traffic on I-55.
This doesn't deal with just a car, but in some instances, for example, outside of Memphis, Tennessee, a four-lane, a federal part of a four-lane was blocked with pedestrians who were not permitted to be on the four-lane in protest. And in that particular case, there were ambulances on the way to a hospital to take someone had been in an accident and couldn't get to the hospital because of the protesters. I support and I respect the right of people to be able to protest. It's a First Amendment right. I want to see people exercise their freedom, but you have entire cities and counties to do this. All this bill is trying to attempt is to codify and to increase the fines for those that would obstruct a roadway or a highway. Well, sure, surely you support free commerce. I mean, the movement of products and people on highways without them being interrupted by pedestrian protesters that aren't properly permitted. Would you agree with that? Yeah, that's the intent of this, and that's why I was so willing to talk with those that are civically minded about the protest, to respect the rights of them to protest, and I'm willing to remove public roads from the bill and just focus on highways and interstates. I think we all want the same thing: a free flow of traffic and goods. on our highways and interstates. Was I able to answer your question? Thank you.
All right, Senator Hill sought recognition first, and then Senator Simmons.
I just wanted to bring up the fact that there's states around us that are considering much, much stronger legislation than this for people blocking roadways. Florida and Tennessee, several other states have, I think maybe have even passed legislation that even provides immunity to somebody that would run over somebody on an interstate highway if they were standing in front of them and would not get out of their way to let them pass on a road. This is extremely mild legislation to address what is a growing problem compared to what some other states are doing that have seen more of this in their state because they understand how serious it can be, you know, and what kind of problems it can cause. And I certainly don't want my loved one to be in an ambulance or an accident or somebody in labor that can't get through, you know, an interstate. And the bill I filed even had enhanced penalty if it delayed an emergency vehicle. So this is the mildest of the legislation that to try to address something that's a growing concern. And there was a protest in Columbia, Mississippi on Highway 98 where some folks from out of town came and blocked the road after some of these police deaths and things across the country. And it almost turned into the citizens handling the blocking of the roadway. So I think that, you know, anything to deter somebody from wanting to do this, because we don't want people hurt. That's the main thing. And we don't want people delayed that are trying to get to the hospital, because they have every right to go down that road and be able to get to the hospital, get to work or wherever they're going. And they don't need to have to worry about the road being blocked. And I think that the other code section could have been amended, but it was not amended. This was a special code section created because this is maliciously blocking a highway to keep commerce from passing. And I just personally don't think $1,500 fine is excessive for somebody that refuses to move when I'm trying to get to work or trying to get somebody to the hospital.
All right, Senator Simmons asked for recognition next.
Yes, Mr. Chairman. Thank you. I was trying to just pull up this statute, and because there's been a lot of talk about an existing statute, and I have it, Mr. Chairman.
Yes.
It's 97 35 25, and can the attorney pull that for us? 97 35 25. And what I have is obstructing public streets, willful obstruction of use by impeding traffic. And it's very specific. It says, it shall be unlawful for any person or persons to willfully obstruct the free, convenient, and normal use of any public sidewalk, street, highway, alley, road, or other passageway by impeding, hindering, stifling, retarding, or restraining traffic or passage thereon. And any person or persons violating the provisions of this section shall be guilty of a misdemeanor, and upon conviction shall be punished by a fine of not more than $500 or by confinement in the county jail not exceeding 6 months, or by both such fine and imprisonment. So I would, I guess, offer that the penalties that we have in this proposal, if we just put it in the existing law, if the issue, as what I'm hearing Senator McMahon say, is that the penalties are not stiff enough or they too lenient, but as far as the actual law, Mr. Chairman and other members of the committee, we have a law in the books. And so, I mean, we come here every year to either amend laws, you know, create new laws, or, and to me, it seems like we are trying to address something that is already on the books. And the concern is, it's just not strict enough.
So is your argument that we just don't need this bill? Or are you arguing for an amendment to the bill?
I don't think we need the bill, but I guess if it's the committee, the will of the committee, that my amendment be, and I don't know what legal help me with it. My amendment be strike the bill in its entirety, insert 973525, and add the penalties that Senator England with the first offense, second offense, I guess.
Senator Super.
I mean, Senator Super, I'm sorry. I'm sorry.
We don't
I'm
want to
sorry.
promote him that quick.
I would suggest that's certainly germane to that code section would be germane as far as the amendment goes. I'd suggest maybe leaving section 1, the Freedom of Roadway Act, and making the imported code section 2.
So,
but I can do that.
So explain it again, Ian.
Leave section 1 as the Freedom of Roadway Act, and then section 2 would be 973525, and I would amend the penalties.
Is there a
And then
point?
strike the
Is
rest.
there a point of order anyone would like to make as to the germaneness of the amendment? I guess that's the question. Okay.
So section 1 again. Let me tell them what section 1 is.
I can strike that or leave that. It would be up to you.
Like I don't think even the title. We don't even need the title. Like the
So
title.
strike. Yeah, I can do that. Strike
Yeah,
the whole
just
bill and put
strike the whole
97,
bill
35,
and just put this because we already have it titled in 973525. But I think the issue is the penalty. So let's just increase the penalties when you engage in that type of conduct.
Okay. You have heard the amendment. Any questions for the author of the amendment? If not, those in favor say aye.
Aye.
Any opposed, nay? The ayes have it. All right. Senator Barnett, I believe, had asked for recognition earlier. You may no longer wish. Okay. And Senator England was next.
No further.
Okay.
No
Senator
further questions.
Wiggins.
Question on the bill as amended. Did we include, if I understand it, did we include the language from the Senate bill into the new code section?
My understanding of the amendment was to strike the Senate bill from section 1 till the effective clause, insert the code section 973525, and then insert Senator Suber's earlier amendment this morning into the penalties.
I
Redo the penalties.
Mr. Chairman.
current
Okay,
code section.
Okay, if I understand it, that's my question is then the current law that Senator Simmons brought up doesn't have the language about unpermitted protest. And the amendment, as I understand it, has taken that language out that's in the bill. And so I think we've basically gutted not gutted it, but we have certainly taken out the unpermitted part of that.
Yes.
Is that okay?
Mr. Chairman, and I also add that the existing statute, if the chairman and the members of the committee will look at it, the suggested amendment modified which type of road and which type of highway, whereas the current statute is broader.
Yeah.
The current statute says any public sidewalk, any street, any highway. So I think with the amendment I made is broader. It's broader to capture the type of conduct on any.
I think you're right.
And you're just increasing
The penalties.
Is essentially what you're doing.
Yes.
Senator Wiggins, did that answer your question?
Maybe, but thank you.
Okay. Other questions? Did I miss anybody? I apologize if I did. Anybody seeking recognition? All right. You.
I did want to ask this. So we
Senator
got a
McMahon.
name to
I mean,
go,
yeah.
to-
Say that again. I couldn't hear you.
I was just asking, we've got a name as well.
Yes.
You just rewrote
If you would like to offer an amendment, you're recognized to do so.
I'd like to offer the amendment that we
Senator
insert,
Hill, you're recognized.
insert the Freedom of Roadway Act, that portion of the original bill, Freedom of Roadway Act. And I agree with Senator Simmons' analysis of his amendment, and we could have certainly started with that code section. It was already there. I realized it was there. And I think the language that's in that original code section is strong enough that you read, that any type of malicious, willful blocking, whether you got a permit or not, I think you're good.
You can't hear us. All right. You've heard the amendment. Any questions? Senator Sparks.
Just one brief question is interstate is not listed in 973525. I didn't know if that wanted to be included in Senator Hill's amendment, if that was intense.
Can I speak to that?
Yes.
I think in some of the definitions in some of the code, the word highway takes into consideration interstate. Because I looked that up a long time ago, because I had a bill myself for this, and I think council can correct me if I'm wrong, but I think highway denotes interstate or state highway.
And I'm fine with that. That was just a legal question.
am
If
I
we
right?
left interstate out, I didn't want to.
I believe that is correct, and I'll check on that.
Okay. Great. Senator Turner Ford. Are you good? All right. You've heard the Senator Hill amendment. Any questions for the author of the amendment? If not, all in favor of her amendment, say aye.
Aye.
Any opposed, nay? The ayes have it. All right. Any further questions, comments, amendments? Chairman, Vice Chairman England for motion.
Yes, title sufficient do pass this committee substitute.
You've heard the motion. All in favor, say aye.
Aye.
Any opposed, nay? The ayes have it. Now for motion to rise and report.
Rise and
Congress. Thank you all.
Clearly, this is one of the hardest working committees in the state Senate. Thank you.
Second only to local